years on criminal law. And I'm the secretary. My name is Vidhamni Modi, and I'm the secretary of this committee, and I welcome you all. For the speaker of this webinar is Advocate Rahul Tiwari, who is a practicing advocate at the Gurugram District Court and Delhi High Court. A quick introduction. Yuvani, if you could please put up the slides now.
Yes.
Rahul Sir completed his legal education from New Law College, Bharat, Pune. He has also obtained his LLM, specializing in cybercrime and economic offences. He was also a panel member of the World Cyber Security Forum and has presented almost 25 research papers in various international and national seminars in Denmark, NLU, Odisha, VHU, CNLU, Patna, IIT, Allahabad, Delhi, and other esteemed institutes. His area of interest are criminal law, cyber law, security, artificial intelligence law, and corporate litigation. We thank you, sir, for joining us in this seminar and giving your insightful knowledge. And whenever you're ready, you can take over.
Okay, so first of all, thank you very much for inviting me. And I think the slides which you have made is quite comprehensive in itself, and I don't think there'll be much addition. So I've just made a few synopses about about what I'm going to speak. And because this webinar is going to be for more than 2 hours, and you don't, if you, and just to ensure you don't get bored, so I would like to make this session interactive from the start. So basically, how man I'll be needing at least 2 to 3 feedbacks that how do you see criminal litigation as a career? Means what are your views about criminal litigation as a career option? Any from the participants? I would like to I would like to know their views, and only then I'll start then. Okay, because considering the fact that we have now the IPC, CRPC, and Evidence Act are going to be amended, and they are going to be amended, and now they will be amended, and we'll have 3 new acts also, which will replace the older ones. So I would actually want to know your viewpoints about criminal litigation as a career. Because see, it's of no use that if I come, I showcase my knowledge, I read out few points, I explain few legal stuffs, and I leave. So it won't make any difference, much more difference to your knowledge. So I would humbly request that I should get at least 2 to 3 answers, please.
So, criminal litigation, according to me, is actually one of the core domains of litigation, because it
Yeah.
gives you it gives you an opportunity to explore the witness, briefings, your client briefings for cross examination and witness examination, and how the evidence is to be placed on
This
record.
cross-examination part, I would like to tell you this cross-examination part and other things, it also takes place in civil litigation also. See, Indian Evidence Act is applicable both on criminal law as well as on civil law. Okay? Yeah, you may continue it now.
Yeah, no, but yes, very rightly put, sir. I mean, it is very much applicable to both civil and criminal litigation. But the essence with which the cross-examination is taken into consideration in the criminal domain of litigation is much more higher than in the civil. Though it is I mean, it is at par at both the pedestals, but yes, I mean, criminal litigation or the prosecution and the public prosecutor then witnessing the defendant and cross-examining the defendant. So it gives a very wide range of experience and exposure, wherein a person can learn a lot uh, uh, through the process, also by just observing the process and being a part of it. Yes, that will be also. Thank you.
Fine. Any other participants who would like to contribute?
There's another thing that I would want to add is that the criminal litigation is,
Yes, I
uh,
have
I mean,
heard
when
your
we talk
view.
of criminal litigation,
Mm-hmm.
sorry,
Yeah, yeah,
so
go on, go on.
it is in rem and not in personam. So basically, the criminal litigation is the society is fighting against the defendant. I mean, the public prosecutor is putting across the charges once the charge sheet is filed by the police and trying to make sure whether the person has committed the crime and eventually get him to the punishment that he should, that he is liable to get. Yeah, that'll be all.
Thank you. Anyone else? Anyone? Participant, come on. It's okay. You can end up making mistakes also, but I actually, and I have just note down one of the point of Pranab, and I would like to discuss with all of you so that this thing gets clear in your head. So please, I would like to know one more view at least from the participants. Please.
Um, I think that the very sense of upholding justice that is more pertinent in criminal litigation than in civil cases.
Okay. Just for the justice, but justice better take place in civil also.
No, the creation of a better society to prevent wrongdoings.
Okay. So that will be much more related to criminal justice administration. Okay, not criminal litigation. See, those are two things. One is criminal justice administration, that how things goes and how the police work, how the prosecution works. Both are different. Police is for investigation, and then for the trial part we have the prosecution. Okay, so it all involves under criminal justice administration. Okay. Now, anything else you want to add?
Good afternoon, sir.
Yes, yeah, this will be
I
the
want
last.
to.
Yeah,
Good
please,
afternoon.
please.
Am I audible?
Yes, you are audible.
I want to add that in criminal litigation, investigation forms a very important part since in civil everything is recorded and there is a dispute between the relatives. But in criminal, the people we communicate with, it's about society as a whole. So criminal litigation is very important, and the investigation forms a important part of it.
Okay, fair enough. Okay, so before I proceed further, I have noted down your points, and within the course, I'll discuss each and every point. Okay, so now can we move to the next slide where you have made the brief synopsis? Just, yeah, this one. So, comprehensive range and skills which student need to know. See, first of all, I'll request that if you have Barrett with you, please open it, and especially of IPC section 299. Okay, and even if you don't have it, now I'll start with the proper workshop. See, the thing is, why criminal law becomes interesting is because see, obviously. Where except from the few states in India, the crime rate is on the higher side in India, and we see lots of sensational. Even the media also sensationalize few crime reportings, And ultimately, and from the beginning, we are actually a bit fascinated towards the criminal law, why the crime takes place, what is the motive behind the crime. Okay. And then this crime thrillers, crime web series, and everything, they are also they are also something which actually generates a lots of interest from the masses. So first of all, we have to first understand what is criminal litigation is all about. Criminal litigation, first of all, you have to understand the before we move forward, you have to first understand the hierarchy of the court. And the hierarchy of the court is the lowest judge is sorry, we don't call judge. See, first of all, whenever you'll see now, if you are confused that what is the difference between magistrate and a judge, okay? So the difference is simple. Whenever you see judge written anywhere, okay, so it simply means that that particular judicial officer will deal with civil cases. And whenever you will find magistrate as a judicial officer, because see, magistrate part, people get confused with the IS officer also. So that's why I'm precisely using this word, that whenever you find a judicial officer who carries uh, this term magistrate, means he deals only in criminal cases. Okay, so this part is clear. And now see the hierarchy. Hierarchy is the lowest judge is the judicial magistrate second class. He gives punishment up to 1 year. And then above is the judicial magistrate first class. He can give punishment up to 3 years. And then we have chief judicial magistrate. And chief judicial magistrate, this will be your assignment, and I would like to, okay, I'll not give the assignment because it's a 1 day webinar, so there won't be any time for evaluation. So I'll tell you in the one of the judgment in Gujarat, Delhi administration versus state of Gujarat, it was held that the chief judicial magistrate is the head of magistracy. Just I'll explain this part I'll explain this in the coming part. See what happens. First is judicial magistrate second class, who can give punishment up to 1 year, and then after gets promoted to judicial magistrate second class, sorry, judicial magistrate first class, he can give punishment up to 3 years, and then he finally becomes chief judicial magistrate. And the chief judicial magistrate controls all the police station in a given district. Okay, because and then we have all the district, all the police station are uh, divided into their respective jurisdiction, and we have judicial magistrate first class and judicial magistrate second class controlling such police stations. And see, in one district, suppose there, I'll give you an example. In one district, suppose there are 5 police stations, then those 5 police stations will be divided amongst the 5 judicial magistrate first class. Okay, because and why? Because see, and that is where the see the first line, the importance of bare act. Okay, let me brief you in another way. See, you must have heard about your seniors that you must have heard about your seniors that whatever you study in the law school is not applicable in the courts and everything. Trust me, I'm going to say something very much different. Is that whatever you study in your bare act is something which is always applicable in the court. It is something which is applied in the court, and it's a myth that whatever we study, it's not applied in court or it's not there in the court. No, it's a huge myth. See, because why? In whenever you read section 2 of CRPC, when you will read section 29 of CRPC, you will find out that exact power of these magistrate or judicial officers are defined. And like suppose I'll give you another example. If a person has committed a murder, he will be punished under section 302 only. He won't be punished under section 376. Section 376 talks about the punishment of rape. Are you getting it? So you have to understand that for a lawyer, whether you go into civil litigation or criminal litigation, and especially in criminal litigation, you need to have the mastery of bare act reading. And take my words, being a criminal lawyer myself, the bare act is your holy Gita or Bible, whatever you say. Okay? It is the most important book. I'm not saying any book like Kelkar or Ratan Lal. No, it is the most important text for you, for any lawyer or for a law student. Whether you want to become a litigator or whether even if you want to crack judiciary, Bare Act is the most important thing. Okay, you simply cannot ignore the Bare Act. So now coming back to the jurisdiction again, lowest is the judicial magistrate second class, punishment up to 1 year. Then judicial magistrate first class, punishment up to 3 years. And then judicial magistrate, then we have chief judicial magistrate. Now in one district, like suppose, let's take an example of Calcutta. Suppose Calcutta is divided into five different tehsil or five different subdivisions. Then each subdivision will have, or then each such subdivision will have the executive magistrate, IS officer. That's a different thing. But all the police station will come under that judicial magistrate first class. It means that as per you must have seen, you must have heard about this hierarchy that if you want to register an FIR, okay, if you want to register an FIR, first you will go to the concerned police station, then you go if the police does not register your FIR, then you go to the superintendent of police. Then if the superintendent of police refuses the FIR, that I'm not going to register FIR because according to him, irrespective of the reason, it can be political pressure also, or the police officer feels that no cognizable offense is made out, then he can refuse. He cannot refuse. But if he refuses, then under section 200 of CRPC, you go to that particular judicial magistrate and you register your complaint. The judicial magistrate will look into the complaint. It will see, okay, the offense is made out and the police has refused to register the FIR. It will take the cognizance. He will use the judicial magistrate will use his cognizance power mentioned in section 190 of CRPC, and in section 156 clause 3 of CRPC, he will order the police to register the FIR. Or else, if he finds that he does not have the jurisdiction to either try the matter or he will need to accept the complaint, he will still receive the complaint and he will transfer to that particular authorized magistrate who has the jurisdiction to try the matter. And that is why the importance of judicial magistrate comes into the picture. Even if they even if they have the right to give punishment up to 3 years, still they have the right to receive the complaint of murders. Like for murder, we have either life imprisonment or we have death penalty. And if police is not registering the FIR, the concerned judicial magistrate can still register the complaint. And that is the power of judicial magistrate. He has the power to take cognizance also. Okay. So now I hope this much part is clear to you about the jurisdiction part, about the hierarchy part. And now I'll give again, because there is a reason I'm considering that all of you are quite freshers and law students. So it is important for me to keep repeating the jurisdiction part so that it fits into your brain. Now, judicial magistrate second class, first class, chief judicial magistrate. All these three courts are called magistrate court. And once he gets promoted from chief judicial magistrate, or any advocate clears the higher judicial service exam after 7 years of practice and attaining 35 years of age, then in such cases, he becomes additional sessions judge. Sessions means now when you go to the court and if you see it is written additional session judge, means the particular judicial officer will look into criminal matters And if you see ADJ, additional district judge, means that particular judicial officer will look into civil matters. And although the proper hierarchy should have been that in every district there should be two senior most judges. One judge should head the criminal aspect, criminal cases, and other judge should look into the civil cases. Okay. So now, up to chief judicial magistrate, it is called magistrate court, and then above that, it is called those additional sessions judge and district and session judge. Those courts are called sessions court. So such court does not have any limitation on the punishment. They will register they will receive the complaint from the magistrate. They will try the matter, and they have the power to give punishment up to 10 years also. They have the power to give punishment of life imprisonment, and they can give the punishment of death penalty also. So I hope this much part is clear to you, that magistrate court and sessions court. Now moving forward. And again, I'm telling you, when you'll read the Bayer Act, all these things are mentioned over there. And now, why I'm saying about the Bayer Act part, see, why I'm putting so much of emphasis on the Bayer Act, I'll tell you, is that, uh, see, every person, always try to remember this thing, every person is biased in nature. Okay, every human being is simply biased in nature. So even if tomorrow I'm writing any book, irrespective of the fact how even if I try to remain 100% neutral, even if I try to remain 100% neutral, I won't be able to, because I'm a human being. So somewhere down the line, in any of the book, you will see that there is some amount of partiality or some amount of biasness, in whether it can be in the form of ideology or preference in the case laws, or in anything, you will see certain amount of biasness. And it is not someone's fault. It is the basic human nature, that every human being, irrespective of their claim, is biased in nature. Okay. And that is why when you read the Bayer Act is simply the actual law which is printed in this in such yellow books, and with a brief explanation. So whenever you read the Bayer Act first, you actually read the law. And and then when you read the book, you read the interpretation of the law by such author. So like, for example, let's take an example of KD Kaur. It's a very famous book published by the author KD Kaur for IPC. So if you read IPC Bayer Act first, so the idea is, first you read the IPC Bayer Act and then you switch to the book to get a deep understanding. But if you straight away open KD Kaur, a book, to understand criminal law, that is where you won't be reading. I'll tell you, that is where you won't be reading actual IPC. That's where you'll be reading. That's where you will be reading the interpretation of IPC by KD Kaur. And that is why the IPC, that is why the Bayer Act reading is essential. Why? Because it actually explains the law at the first instance. And I'll give you one more example. See, okay, can I'll be asking one question. Like, give me an example. You must have seen, if a person, okay, if a person shoots a pregnant woman, okay, if a person shoots a pregnant woman and the pregnant woman dies, and the woman is 8 months, let's take an example, the woman is 8 months pregnant, okay, then how many deaths takes place? Can anyone help me with the answer?
Two.
Huh?
Two.
Two.
Okay, anyone else?
So when the women enters the third trimester, the fetus is considered to be a living, and hence it is going to be considered for two.
It's not. It is not. Because even I had been an faculty in Indore Institute of Law for 1 year, so I will not disregard any faculty. But fetus is never considered as a living person. So kills, if a person, okay, if someone kills a pregnant woman, it is just one murder, not two. And it is not me who is saying it. Now open your Bear Act and read section 299 first. And that is where the difference comes in reading Bear Act and reading book. See what happens when you will see, it's a human tendency to, first of all, I've told you it's a human tendency to be biased, okay? And again, it is a human tendency. It's a human tendency, I'm telling you, to self-assume a lot of things. If you understand few things, see, it's a human tendency, I'm telling you. If you understand 5 things, the human being or human mind has a tendency to assume 5 other things related to it. So whenever you start reading the Bear Act, what will happen? You will read whenever you start reading the book, if you start reading the book, you will understand. If you understand few concepts, then what will happen? The further things, you will assume it at yourself and you will mix the thing. Like for example, if you read section 299, it clearly says whosoever, means whenever you read the Bear Act and if it is written whoever, means the crime is gender neutral. Whoever commits murder or kills a person, means act has been committed, means for a murder or culpable homicide, a death is essential. With an intention of causing death, mens rea, or with an intention or causing a grave injury which can cause death, or with the knowledge that the act which is being committed can cause death. So here, knowledge also comes into the picture, and if either one is present and a person dies, it's a murder or it's a culpable homicide. But in the Bear Act part, when you will straight away come down after reading the illustration, you will see explanation 1, means if someone has suffering from any venereal disease and if someone escalate that disease, then also it's an culpable homicide. Like for example, I'll give you a very good example. You can seriously connect to it. Suppose there was a web series called Breathe, season 1, where the actor was Madhavan, and he knew that one of his victim, that one of the person is suffering from high blood pressure. Okay, so he's suffering from a disease, high blood pressure, and if he makes that person run on a treadmill at a particular speed for this much of duration, he will die, and the police will think that it's an accident, and he'll be saved, and that's what he did. On gunpoint, he asked that person to run on a treadmill on a particular speed for a particular duration of time, and that person dies of heart attack because he was a patient of high blood pressure. So that thing also comes into the murder. Explanation 2 also talks about injury, and explanation 3, it clearly says that killing of a pregnant woman does not amounts to killing of uh, does not amounts to two culpable homicide. It only amounts to one. Suppose a woman is pregnant, a pregnant woman is going somewhere, and a person shoots that lady, and that lady dies. Then it is only one murder, and it will be considered two murder only if, I'll tell you, only if the at the time of delivery or at any given instance, the any part of that child is outside the fetus. That time the law assumes that the person has become a living person. And if that person becomes a living person, then only it becomes two murders or two culpable homicide. Otherwise, if a woman is pregnant, then the fetus is always be called as non-living person, and the non-living person and a person or a thing which is non-living in nature cannot be killed. Okay, so this much part is clear to you. And now, how do we interrelate the provisions of Bail Act with the other provisions of law? Okay, now again I'm saying, according to IPC, that person cannot be killed. A pregnant woman, if a woman is pregnant and the child is in his or her mother's womb, okay, then the child, sorry, he cannot be killed. But the unborn child also has the right to property. According to Hindu Succession Act, the unborn child also has the right to property. So now if you say that, isn't this confusing that an unborn child cannot be killed? But the same unborn child or a non-living person has the right into his or her ancestral property. How is it possible? It is possible. Why? Because till the time that baby is inside the mother's womb, he cannot be killed. But he has right to property. But when he will exercise his right to property, once the birth of that child takes place. So if there are 4 family members and a woman is pregnant, then it becomes that there are 5 family members and a particular property will be divided in 5 equal share, and the child who is in the mother's womb will inherit that property once he or she takes birth. But if at the time of delivery or due to any reason, or it can be due to miscarriage also, or any other biological or medical reason, the child dies, then his share will be divided amongst the other members of the society, other members of his family. I hope this much part is clear to you, because then I will take other examples of the Bail Act. So I hope everyone has understood this much part. Okay, Anshul Nandwani, yes. Okay, Manshi has asked that, can a woman be ever rape, ever be, okay, I've understood, can ever be held for rape? No, although she can get the same amount of punishment. See, now, Mansi, there are 2 types. Whenever you read the definition of rape, section 375, it clearly says a man. So according to IPC, a woman cannot rape. But suppose a woman hires an henchman or a mercenary, and he asks that mercenary or a henchman or a gunda to rape another woman. And on his provocation, or his abate on or on her abatement or her inducement, the woman, that man rapes another woman, then in such cases that woman will get same punishment as the rapist. Okay. Yes, Ayush, you are definitely right. So I hope this much part is clear to everyone. Any person, if you have any other participants, I'll request, if you have any doubt, you can ask right now, and then only I'll proceed further. Uh, no, she cannot be charged for sexual assault. See, I'll tell you, Mansi, what actually happens. See, in abatement, suppose as per section 107, read with section at the present IPC, read with section 115 and 116. If I provoke someone to commit a crime, okay, and he commits the crime, then me, that then I and that accused will get same punishment. Okay, so if a woman abates a man who rapes another woman, then that woman will also get the same amount of punishment for abatement of rape. But if I abate a person to commit any crime, but the person does not commit the crime, then in such cases, the second person will not be held responsible for any crime. But if it is proved that I tried to abate that person to commit a particular crime, then I will get 50% of the punishment of the offense. Means if I'm provoking someone, or I'm abating someone, or I'm inducing someone to commit a crime, okay, to commit a crime where the punishment is of 10 years, and he commits the crime, then in such cases, the actual criminal and I'll get the punishment of 10 years. But if he does not commit the crime, then in such cases, I'll get the punishment up to 5 years. Okay. Are the provision regarding rape in the new penal laws still, or they have made it gender neutral? Anshul, I don't think that rape, it is that easy to make rape as gender neutral as of now. Okay, because I don't think it's the right time also, and the lawmakers are either the lawmakers or the society is ready for such laws, for a gender neutral law, for especially for rape. Okay. So now I hope this much part is clear to you, and I hope now you have realized that the importance of Bail Act. I'll give you another example now. Bail. Like if you are reading criminal law, if you are practicing criminal law, or if you have interned under any criminal lawyer, then you must have understood that the bail is the bread butter of whether the new advocates or an experienced advocate. Bail also plays a huge role in the monthly billings of the advocate. Now, if I tell you, okay, if I tell you that, see, uh, before moving forward, I'll explain this part. See, as per section 436, if a person is arrested, now understand this. What is an bailable offense and non-bailable offense? Bailable offense is where the police can give you bail. Okay? Always remember this thing. Whenever you'll read the section for bail, in most of the places, you will understand, you will see. Okay. In most of the places, you will see that the provision of may is used and not shall. It means that the bail is your right, but granting bail is at the discretion of the judicial officer. Okay. See, filing a bail application, how bail is adopted, when you will in turn, you'll get to know each and everything very quickly. But the basic crux is that you must understand its basics, in the basics of the bail, and the what the bail actually wants to say. So in most of the places, I'll again repeat, you will find that it is written may. It means you must have come across this phrase that jail is an exception and bail is rule. Very true. Getting bail is the right of an accused, but granting bail is not a mandatory provision for the magistrate. The magistrate can grant bail, or the magistrate can reject bail also, and that is why you will see that in most of the places it is written may and not shall. Now, again, what is a bailable offense? Bailable offense are those where the police can give you bail. The police has to give you bail. And if in any case the police rejects your bail and they puts you behind the bar, and if it is a bailable offense, then when you will read section 436, uh, uh, clause 1, in the last part, it is written such person shall be released on bail. Means if it is a bailable offense and the police does not give you bail, means the police has the right to give you bail, but the police feels that okay, if they give you bail, you will abscond or you will tamper the evidence, the police arrest you for a bailable offense. Then in such cases, if the offense is bailable, the court has to give you bail. Okay, that is why you will see it is written in section 436, shall is used. Okay, in the last line of clause 1. So if it is a bailable offense, you can take bail from police, and if the police does not give you the bail, the court will definitely give you bail. But if it is a non-bailable offense, then in such cases, for such offenses, the police has no power to give you bail. And in such cases, it is only, and in such cases, it is only, just a second, okay. In such cases, there is on, it's the court which will give you bail. Okay, that is the difference between bailable offense and a non-bailable offense. Cognizable and non-cognizable. Cognizable offense, the police can arrest you without the warrant. Non-cognizable offense, if they are usually the bailable offense, in such cases, unless the magistrate issues the warrant, the police cannot give you the bail. The police cannot arrest you. Now you'll come across the term called compoundable and non-compoundable offense. Compoundable offense are simply those offense where the parties, the accused and the complainant, can compromise and withdraw the complaint. Okay, keep this thing in your mind. Okay, and non-compoundable offense are those where if the FIR is registered and the police files the charge sheet, then either acquittal will take place or conviction will take place. They under no circumstances, under I'll again repeat, under no circumstances the person can compromise and settle their dispute. No. Why? Because see, in civil cases, what actually happens in civil cases, what is the penalty that if a person wins the case, the losing party has to pay the interest or penalty. Why? Because it's civil dispute. In criminal cases, there is no scope for penalties, but in civil criminal dispute, it is always the fine. Fine is paid to the state. And why? And in criminal cases, you must have heard, like if a accused is X, then it is written state of West Bengal, or but that particular state name, state of West Bengal versus X. Means when you commit a criminal case, sorry, when you commit a crime against any person, then it is assumed that you have committed the crime against the state. Why? Because why? Because it was the duty of the state, not union. I'll come back to that also. It is the duty of the state to maintain the law and order and to protect its citizen or residents, or their voter, whoever is living in their state's territorial jurisdiction, to protect them. And if any crime takes place, it is assumed that you have committed the crime against the state. And now if you will say that Rahul sir, you have said against the state and not against the union, then again the answer is in Barrett itself. The Constitution Barrett simply says that we have three lists: state list, union list, and concurrent list. Yeah, union list are those subjects where, like defense, foreign affairs, and other things, where the center will where the center will take all the decisions and they will make all the laws, and law and order falls under the list 2, which is the state list, and that is why it is always the state government's responsibility to maintain the law and order. So I hope this much part is also clear to you. In the criminal case, you will always find the name of the state as the party. In criminal case, there are two parties then. One is the three parties basically. If the FIR is registered, it will be the duty of the prosecutor to conduct the trial and to get the accused punished. then we have the defense side, and then we have the third side also in criminal litigation, which is the complainant side. So such complainant's advocate can either conduct the trial if it is the wish of the party, or after the permission of the judge. Otherwise, it is usually the public prosecutor, or the complainant's advocate can do max is that he can assist the public prosecutor as a complainant. Okay, so in criminal cases, these are the parties. So I hope this much part is clear to everyone, and then I'll proceed further with the bail part. Any doubt up till now? Okay. Now, whenever we read section 437, now the first line itself, usually you will say, you'll hear your senior or other colleagues telling you this, that if it is a non-bailable offense, the bail is granted by the court under section 436, and if it's a bailable, if it is a bailable offense, the bail is granted by the court under section 436, and if it is a non-bailable offense, the bail is granted by court under section 437. No, whenever you read the line 437, the first line itself, what does it say? It says when bail may be. Again, now I'm telling you, in section 436, we had shall. Why? The court shall grant bail. Why? Because it's a bailable offense. Okay. So if it is a bailable offense, the court shall give you bail. But if it is a non-bailable offense, so whatever I'm saying, it is mentioned in your Bail Act. And see, I have my criminal manual with me. I'm not referring to any books. So always remember one thing: if you want to become a good lawyer, you don't have to touch any book. I know it's a quite unconventional thing which I'm saying, but first develop a habit of reading Bail Act, and then only uh, switch to and then only switch to any book. So the Barrett clearly says when bail may be taken in the case of non-bailable offense. So the definition itself says that it is the discretion of the judge to whether grant you bail or to reject your bail application. And that is what the importance of Bail Act. Now, again, one more interesting part is there. Now, the clause 1, what does it say? 437 clause 1, it says when any person accused of or suspected of the commission of non-bailable offense is arrested, means the person is in the custody. And now in custody also, there are two types of custody. One is the police custody. Second is the judicial custody. See, judicial custody is when the person is sent to the central jail. Police custody, where the person is kept at the police station for the investigation and questioning. Now, I would like to explain one more thing to you. Earlier, what actually happened is that earlier it was that if a person used to be arrested on day one, like suppose today's date is 23rd of August. So if a person is arrested on 23rd of August, then what does Article 20 and 22 says of Indian Constitution? That he has the right to fair trial, and 20 in 21, and he has to be presented in front of magistrate within the 24 hours of the arrest. Means the police has that power of 24 hours with themselves. Okay. So now, earlier, before this famous judgment, and the judgment, it will be your homework, and whenever you'll find, because I know the judgment, it came into the 2023. If you find the judgment, do let me know on LinkedIn, on my on LinkedIn, and in my inbox. See, earlier what used to takes place is that suppose a person is arrested on 23rd of August, then he used to, the police has 24 hours of time. The police will investigate, the police will try to gather as much information from the accused, either by any means, and then on 24th of August, the accused will be presented to the in front of the judge. The prosecution will oppose the bail. The defense will apply for the bail. The bail argument will take place. And I'll humbly request that please don't leave the meeting for till last, because now I'll start sharing a lot of real life experiences and not the bookish example. Okay. Now what will happen? Both the sides will argue. The prosecution will ask. The prosecution will ask for police custody, and it is a settled law. It is clearly written in section 167 of CRPC that the police custody under any circumstances cannot exceed for 15 days. Now, the confusion arise that now what actually used to happen up till now? Accused is arrested on 23rd of August. The the accused will be presented on 24th of August in front of the magistrate. Defense will apply for the bail. Prosecution will oppose the bail. The prosecution will apply for the 15 days police custody. For example, usually the courts does not give 15 days police custody at one go. They'll either give 4 days, 5 days, 4 days, 3 days, okay, 2 days, 3 days, maximum 10 days. And actually, someone has opened his mic. So I'll request please unmute, keep yourself at unmute, and only mute yourself or when I'm asking. And if the disturbance continues, I'll leave the meeting. Good. Now, what earlier used to take place is that accused used to be arrested on 23rd of August. He is presented in front of magistrate on 24th of August. They used to apply for the police custody after opposing the bail. The judge used to, if the offense is serious in nature, the judge usually used to give police custody. Let's say the judge gives 15 days police custody. So that 15 days police custody used to start from the 24th of August. Okay. Now it was appealed in the Supreme Court that that particular 24 hours which the accused remains in the police custody after getting arrested should also be included in that police custody period. And for example, and for your knowledge, I'll tell you the I'll tell you that police custody is also called remand period. Okay, remand is nothing but police custody. So that should be included in the remand period. And then in this year itself, uh, this year it's where it is, yeah, exceeding 15 days. Yes. So this year itself, in Supreme Court, in their landmark judgment, it held that those particular 24 hours means earlier the remand period used to start once the magistrate used to give it in writing. So magistrate used to when the magistrate will give in writing once the accused is presented in front of him. So the earlier the remand period used to start from 24th of August. Once the magistrate says, okay, remand period start. But now the Supreme Court has said that the remand period starts automatically once the accused is arrested. Why? Because section 167 clearly says that accused cannot be kept in remand for more than 15 days. But what was coming into the practice, that it was always 1 day of the arrest before being presented to the magistrate, and then 15 days remand period. So what used to take place? It was 1 plus 15. It used to comes out to be 16 days remand period. So that is one ambiguous area where the Supreme Court in 2023 itself has given the clarification that when will the remand period start. So I hope this much part is clear to everyone, and then I'm moving forward with section 437. Is it clear to everyone? Okay, cool. Now, section 437, let's read it out. Bail application, okay? Section 437, when bail may be granted. When bail may be taken in case of non-bailable offense. Now, when any person is accused of, or, now understand this word or also holds a huge meaning. But again, I'll explain this when I'll be explaining you section 439, okay? Not this time. When a person is either accused of, means if a person is accused of, okay, means he is not arrested, or suspected of a commission of any non-bailable offense, is arrested, or he is detained. Okay, I'll read this again. See, when any person is accused of or suspected of the commission of non-bailable offense is arrested, means the person is either arrested or the person is detained without warrant by the officer in charge of a police station, or appears or is brought before the court other than, now read this part, other than High Court or Court of Session, he may be released on bail. But wala aage wala part, just leave it right now. So basically, I wanted to tell you the importance of section 437 clause 1 itself. What does it say? When a person is either accused of or suspected of, and the person is arrested without a warrant, or a person is detained, okay, then if that person is brought in front of any judge, which is either which is not High Court or Court of Session, then this section is talking about which court? Please tell me. Suppose if you have to apply for bail under section 437, you will apply in which court? Anyone? Okay, just wait. See this part again. It clearly says is brought to the court, which is which court other than the High Court or Court of Session, he may be released on bail. It means it is talking about the magistrate court. It can be the judicial magistrate first class, or it can be chief judicial magistrate. Okay. Again, for your information, I'll again explain the jurisdiction. Judicial magistrate second class, it gives punishment up to 1 year. Judicial magistrate first class, it gives punishment up to 3 years. And then above it is judicial magistrate, chief judicial magistrate. The chief judicial magistrate can give punishment up to 7 years. All these things are mentioned in section 29 of CRPC. So, judicial magistrate second class, first class, and chief judicial magistrate. 1 year, 3 year, and 7 years. So, as per section 437 clause 1, now we have clearly understood that, now we have clearly understood in this section that it is talking about the offenses where the punishment is less than 7 years, and this bail application will be filed either in judicial magistrate first class court if the offense is less than 3 years, and if the offense is the offense is more than 3 years, then the bail application will be filed in the court of Chief Judicial Magistrate. This much part is clear to everyone. Please write in the comment box and then only I'll move forward. Or you have not understood, I'll repeat again, don't worry. Because again, I'm telling you, the idea is to make you understand. The idea is not to come and show off my knowledge. Okay? Okay, fine. So, Section 437, Clause 1 clearly says a person is either arrested or detained and is brought in front of the court other than High Court or Court of Sessions. तो कौन सा court बच गया? It is only the Chief Judicial Magistrate Court or JMFC Court, Judicial Magistrate First Class Court. Okay? So, in such cases, it is clearly understood that the offense, if the offense is committed and the punishment is now let's revise. Now, if a person commits a crime, non-bailable offense, a non-bailable offense where the punishment is less than 3 years, it can be domestic violence. Okay, a person has committed a domestic violence case, he is arrested. Then in which court he will file a bail application? The Judicial Magistrate First Class. Okay, in the Court of Judicial Magistrate First Class, which has the jurisdiction to try the matter, you will file the bail application over there. Now, if a person has, if the offense is that a person has caused a grievous hurt to other person, now the punishment with the dangerous weapon, now the punishment is up to 7 years. Then what will happen? You will apply for bail application under Section 437 in the Court of Chief Judicial Magistrate. I hope this much part is clear to everyone. Okay. If the offense is less than 3 years, you will file bail application under Section 437 Clause 1 in JMFC Court. If the punishment is more than 3 years and less than 7 years, you will file the bail application in the Court of Chief Judicial Magistrate Court. This much part is clear to everyone. Then I'll move to Section 437 Clause 2. Is it clear, everyone? Please write in the comment box or please let me know. Okay, fine. Great. Great. Thank you. Okay. Now, see, you have understood about this part, right? Now, coming to the if it appears at any stage in inquiry, no reasonable ground. Now, always remember one thing: if you are going to become a criminal lawyer in future, the second aspect, no, let's ignore this part. So up till now, what we have understood, I'll go in a linear way. Up till now, we have understood that if an offense is less than 3 years, you will file bail application under Section 437 in the JMFC court, and then if the offense is more than 3 years and less than 7 years, you will file bail application in the CGM court. Now comes the catch. Didn't I tell you at the start of the workshop that the CGM holds the controlling power of all the police station in any given district? Okay, this much part is clear again. Now what actually happens? Now let's come to Section 439. Now, up till 7 years of offenses, we have understood about the offenses where the punishment is 7 years. Okay. Now, if the offense is committed, where the punishment is more than 7 years, then what will happen? See, if the punishment is less than 7 years, then magistrate court gives the bail. Keep this thing in mind. If the punishment is less than 7 years, magistrate court gives the bail. If the punishment is more than 7 years, the session courts or the high court gives the bail. Understood this much part? And again, it's not me who is saying this. It is the Bail Act. It is clearly written in the Bail Act. And now we will read about section 439. What does it say? Special power of High Court or Court of Session regarding bail. Okay. Now, clause 1, it reads as a High Court or Court of Session may direct. Again, may is used. So it is clear that if it is a bailable offense, shall provision is used, that the court will give you bail. And if it is a non-bailable offense, it is the discretion of the court whether to grant you bail or to reject your bail application. It is mentioned in the section 437 also, and it is mentioned in section 439 also. Now, basically 439, it talks about that if the punishment is more than 7 years, then the session courts gives the bail, except for the special circumstances. Now special circumstances वो हम लोग बाद में करेंगे, अभी लीनियर वे में चलते हैं. It says punishment where offense where punishment is less than 3 years, you will file bail application under section 437 in the JMFC court. Punishment more than 3 years, punishment more than 3 years and less than 7 years, you will file bail application 437 in CGM court. Now, offense where punishment is more than 7 years, then you will file bail application in the Court of Sessions or in the High Court. Now, and again, it's their discretion whether to give you bail or to reject your bail. Why? Because the may provision is used under section 439. Now, see this part. Can you see this part? Whenever you read the Bail Act, now the essential how is that, see, the language of Bail Act is, I understand it is quite tough. It is quite confusing also. But everything revolves around the Bail Act itself. So you cannot run away from the Bail Act, right? So you have to develop the habit of reading the Bail Act, and you have to develop the art of living the Bail Act, means how the Bail Act is read. And now we have some rules of reading the Bail Act. See, whenever you read the Bail Act, never read 3 to 4 lines in one go. In that case, what will happen, students, that you will get confused and you will close the Bail Act and find like, this subject is so boring here. I don't want to do law at the first instance. Why? Because look at the language of the Bail Act. It's really bad. Okay? No. The first rule is whenever you see any comma in Bail Act, okay, whenever you see any comma in Bail Act, assume it as a full stop. I'm telling you a trick. Whenever you see a comma, assume it at full stop. Now what will happen? That if you start assuming commas as Bail Act, then those 3 lines, if see, 3 line is in the continuous form, so you will end up breaking those 3 lines into 4 to 5 smaller parts. And when you will break those 3 lines into 4 to 5 smaller parts, you will be able to understand better. Means again, come back to 437 and see this trick. And I'll be reading the Bail Act along with you. It says, when any person accused of, now we have comma, means assume it at full stop. Means when any person, now any person is written, means it can be a male, female, or a transgender. Okay? Because the transgender is also recognized as the third gender now. Okay? So any person is written. Means when any person is accused of, means वो आरोपी है और suspected of, उस पे संदेह है, of the commission, again comma, means of the commission of non-bailable offense is arrested, और को भी हटा दो, is arrested. अब यहाँ ही तक पढ़ो, मतलब any person या तो वो either that person is accused of or that person is suspected of, is arrested. तो यहां तक आपको समझ में आ गया. Or he is detained without the warrant, means the person is either arrested or the person is detained in the police custody without the warrant of the magistrate, means the magistrate has not given any remand period and the person is kept in the police station for 2 days or 3 days, okay, or more or less than 1 day itself, okay. The person is detained by an officer in charge of a police station or appears or is brought before a court. See, in every places, have you ever seen any full stop? No, you have just seen commas. So the trick is assume the comma as full stop, break those sentences into small parts, and then read. Then what will happen, that you will be able to understand the crux of that section. So a person who is either accused or suspected of is arrested or is detained or is appeared, then that person is either brought before a court or he appears before a court. And which court? A court other than high court or court of session, means फिर एक ही court बच गया, is the magistrate court. Okay, this much part is clear. Now the second trick. Come back to again section 439. Again, this after this trick, I'll take a break of 1 or 2 minutes, and then I'll finish the bail application part. Then I'll move to legal research and the other real life cases. Okay, and then we'll have a small interaction session, and then I'll proceed further with the webinar. Okay, now the last part is, whenever you read the Bail Act and you come across this word or, now see this part, section 439, special power of High Court or Court of Session regarding bail. Means this section is talking about what are the special provision of High Court or Court of Session regarding bail. Now if I ask you, in seniority, who is senior, High Court or Court of Session? Answer is quite simple. It is the High Court. But the catch is, whenever you read this word or, then immediately the word before the or, and immediately understand that the word before or and after or holds equal value. Now, it means as per section 439, in the matter of bail, just simply in the matter of bail, और लिखा है, और के बाद क्या लिखा है? It is written court of session, and और के पहले क्या लिखा है? High court. कोई कॉमा है? नहीं है. कोई full stop है? नहीं है. Means this section clearly says that in the matter of bail, where the punishment is more than 7 years, okay, then in such cases, the High Court and Court of Session holds equal value. Again इस बात को गांठ बांध लीजिए, और के पहले और के बाद वाला हमेशा बराबर होता है. It is always equal. Okay, this much part is clear to everyone. But in practice, as per seniority, you always file bail application under section 439 in the Court of Sessions first, and if it is gets rejected, then only you file in the High Court. But regarding the power, then Court of Session and High Court have the equal power regarding bail. This much part is it clear to everyone or not? Please tell me. Because see, it is not me who is saying, again I'm saying this, it is not me who is saying this. I'm just reading out the law in front of you, and that how it is supposed to be, that how it is supposed to be understood. Okay, so whenever you will find or means theoretically both are equal, but in practice usually what happens, say now I will give you a few real life examples and it can act as a break also. See what happens, except in the metropolitan areas, in the matter of, especially in the matter of rape. Okay, uh, I'm talking about there where here I'm talking about anticipatory bail. Always remember, in anticipatory bail, please, if you want to write it down somewhere, you can write it down. The magistrate court has got no power. It is always the court of session who grants the anticipatory bail, or the high court who grants the anticipatory bail. But in the matter of rape, what actually happens, that it is a general practice adopted by the session judges that they will not give anticipatory bail in the rape cases or in forgery or cheating cases where the punishment, especially in the case of section 467 IPC, forgery where the of valuable goods or valuable goods where the punishment, where, just give me 1 minute, where the punishment is in section 467, where the punishment is 10 years. In such cases, you can see in the Calcutta or the other places also, you will clearly find out that session judges, they are reluctant in granting bail, whether regular bail or anticipatory bail. Okay, now I've used this term regular bail. I'll further elaborate once the sessions proceed. Okay, now okay. Now come back to section 437. Now if I ask you, uh, and this is the last theoretical part of the bill, and then we'll move to a few more real life examples. See, what actually happens is in criminal litigation, uh, as of now, I have explained you that CGM court, they grant bail for 7 years, and above that, the session courts grant the bail. Now, it is what the Barrett says. What actual happens is in the real practice is that, see, uh, see what actually happens, that we read law in the law school in a very theoretical manner. We read law just to understand and then to write for the exams, and majority of the students attend classes just for the sake of attendance. Okay, so now what actually happens, that you don't understand the basic crux, you don't understand the basic crux of the practice. And whenever when you go into the field, first you get the enrollment in the bar council. You pay a hefty fees from 15,000 to 25,000. In Odisha, I have came to know it is close to 40,000. And even after paying such a huge fees, the bar council, whether it's the Bar Council of India or the State Bar Council, they don't provide you any adequate training that how the court functions. Okay, and that is where you are at the mercy of your seniors, and that is where the gap arises from the practice and to the theory. But I'll again burst all the myths. It is everything which you see in the practice is mentioned in your BARE. Okay, now up till now we have understood this part. Now if I say, see, अभी तक तुमने बता दिया ना, that in 437 where the offenses where the punishment is less than 7 years, TGM or JMFC grants the bail. where the punishment is more than 7 years, the session courts or high court grants the bail. But now comes the exception. At the start of the lecture, I had clearly told you that CGM controls all the police station. Okay, it controls all the police station, and session courts are just concerned with the cases. So what actually happens is that all the cases which are registered, the FIR which are registered, first it goes to the CGM court. I'm telling you the procedure, and then I will highlight the provisions also. If the case is registered, the case goes to the CGM court. Why? Because he is the head of magistracy. He controls all the police station in a district. So the case goes to the CGM court. If the CGM feels that I am empowered to try the matter, he will try the matter. If the CGM sees that no, the punishment is more than 7 years, then CGM transfers the case to the Court of Sessions. And in criminal law, we don't use the word transfer. We use the word committal. Means CGM has committed the case to Court of Session. Okay. And where is this thing is mentioned about the committal, under which provision the CGM is empowered to commit a case from his court to the Court of Session? It is section 209 of CRPC. So tell me, if someone now, if your senior says that no, don't pay so much attention to the books, whatever you study does not come to the court, tell me, whatever in last 1.5 hours I'm saying, I have said in this webinar, I have always quoted some or the other section of the Bear Act. So now, this much part is clear to everyone, that the CGM, all the case goes to the Court of Session. The CGM says, okay, I can try the matter, I can give the bail. The CGM gives the bail. If I don't give the bail, now the catch. If I don't give the bail, I can't try the matter. I commit the case in the Court of Session, section 209. But now what happens? Now what happens? So when CGM will transfer the case or commit the case to the Court of Session, it will take 1 or 2 days. 1 or 2 days का time लग जाएगा ना? Till that time, the accused remains in the custody, in the police custody, right? Those days are also included in the remand period. Okay, means simply ऐसे समझिए कि 209 में in section 209, whatever time is taken, those time is also included in the remand period. So that the remand period means why it is mentioned this thing. It is done because so that the prosecution do not misuse the provision of remand. This provision is there. Why? Because like tomorrow the prosecution can misuse its power. No? Suppose the accused is arrested on 23rd of August, brought before the magistrate, on 24th of the August, the process is committed. Now the process takes 2 to 3 days. And if the provision is not there, the prosecution will say that those 3 days where the accused was kept in the police custody should not be included in the remand period. Are you getting it? They can misuse in this manner, right? So just to avoid this thing, always remember, under any circumstances, whether it is by the order of the magistrate or the judge, means the session judge, the remand period cannot exceed 15 days. First of all, remember this thing. Even if the committal process takes time, suppose holiday comes or any emergency situation comes, even in such cases, the committal cases, everything, in such cases, that duration again, the time in which the accused spends in the police custody will be counted as remand period. This much part is clear to everyone? Committal part, bail part. Now, see, up till now, again I'll revise. 3 years punishment, 437, apply bail application in the JMFC code. 7 years punishment, apply bail application in section 437 in CGM code. The case is now, I'll add this part in the hierarchy. The case is filed in the police case, in the JMFC court. The case is committed to the court of session. Be relaxed. That duration will also be counted as your remand period. Now the punishment is less than, is more than 7 years, then again apply for the bail application under section 439 in the court of session. Okay, although again I'm saying all the case goes through the channel of CGM court, to CGM court to the court of session. But when you apply for the bail in the court of session, you apply under section 439, because there is a word called or between High Court and Court of Session. Okay, between High Court and Court of Session means High Court and Court of Session have equal power, but for the preference for the hierarchy, we always file the bail application in the Court of Sessions first, and then only we file the bail application in the High Court. This much part is clear to everyone. Now, there is one exception. CGM Court. Now, that's where the highly knowledgeable advocates comes into the picture and how they get relief for their client. See, 437 clause 1. Read what is the last word. He may be released on bail, comma, but. Now see. Such person, just ignore the first and second part. It is for your understanding, because now because if I goes into that detail, this webinar will end at 8 p.m. or 9 p.m. at night. Okay, so I cannot go into that detail. Now, what does it say? Provided means whenever you read the Bail Act, you will see what? First, it will have explanation. Explanation means everything which is mentioned in the section, it is explained further. It is explained more deeply. But if it is written exceptions, means the above section is there. Above section is applicable except in this section. It says except in this condition, above section is applicable. For example, when you will read about rape, what does it say? Section 379, even till today, 375, sorry. Rape is where the penetration of penis takes place, whether into the vagina or into the any body part of the body. Now, when it is written, whether you insert the penis or it, the further definition also explain that it also includes the insertion or penetration of any object in any body part of the woman is rape. Okay, so if you are inserting any object in any body part of the woman, means it clearly says one thing, that it is not necessary that semen will be present inside the body of that woman. And I would like to bring notice into one of the more scandalous and highlighted case, which was a scandalous and highlighted case, which was this Hathras gang rape case, where a woman of a backward community was raped, and the concerned officer, I don't know under what pressure, I really failed to understand. It gave the statement that no rape took place. Why? Because there was no semen present inside the body of a woman. Okay. It clearly says that the no semen is present inside the body of a woman. It clearly goes against the definition of bare. Because what does Beirut says? Beirut says that whether you insert any object into any body part of a woman, it is rape. So, and how we find just give me 1 second. Sorry. So, if and how you will find semen inside of a body of a woman when there is a penile penetration into the woman's vagina. Only then only then there will be semen present in the uterus of a woman. Okay, that is the only way. But the definition of rape is much more in the elaborated form. So that and that just give me another second. Sorry, actually, there is a lots of thing going on in the background, and that was the reason. Actually, I requested that if we can uh, reschedule it, but because they had given the commitment to the participants, they had given the commitment to the participant, and because I have a very good terms with them, so that is why I didn't cancel that webinar. And from the court, I came back running to my home because I have a better network connectivity at my place. So I'm really, really sorry for the disturbance. Okay, now it won't happen. I cannot assure you that again, but yes, no problem. See, again, I'll revise. See, any offense. See, why am I repeating this again and again, so that it fits into your subconscious part of your brain. Okay, so any offense takes place where the punishment is less than 3 years. 437 bail application, JMFC. Punishment less than 7 years, more than 3 years, bail application under 437, CGM. Punishment more than 7 years, the case first is goes to the magistrate courts, sorry, CGM court. CGM commits the case to the CGM, commits the case to the court of session, apply 439 bail, where the punishment is more than 7 years. Okay, this much part is clear. But there are certain conditions, there are certain circumstances where the bail can be granted by CGM, where the punishment is more than 7 years. Now, what are those special circumstances? For that only, I was explaining the provision of Bail Act. Now, rape, rape case, I had explained the provision of Hathras rape case. What actually happened in that case, that if there is no penal penetration, there is no chances that there will be the semen will be found in the woman body. And when you will read the definition of rape in section 375, what actually happens in section 375, what happens, that we have exceptions also, and in that exception it is clearly mentioned for the medical procedures. If there is a penetration, there is no rape, except for the three finger test. Three finger test is now considered as unconstitutional. Means, and if the penetration takes place between an husband and a wife, means up till now, although the Delhi Court gave the split verdict of 1-1. Okay, that is not that important. The Delhi High Court gave the split verdict, but let's ignore that part. Uh, the Delhi High Court and the case in the Supreme Court. But up till now, as per Indian criminal jurisprudence, the husband cannot rape. Understood? See, and that is where the it is clearly mentioned in the exception. Whenever you read the exception part in the Bail Act, it clearly says that the exception, it clearly says that whatever is defined in the definition, it is not applicable over here. But whenever you read the word provided, it is also known as proviso. It means that above part is applicable provided these things takes place. Means, and very recently there is lots of confusion is also going on regarding one of the section in the new IPC, where in the old IPC the proviso was used, and in the new IPC in one of the section the word unless is used. So ultimately it changes the meaning. The proviso is used. Proviso in Hindi it is called basharte. It means that whatever is mentioned in the section is applicable basharte ye cheezein ho jaए. Means, in normal circumstances, CGM cannot give the bail. In normal circumstances, the CGM cannot give the bail where the punishment is more than 7 years. But in certain circumstances, the CGM can give bail where the punishment is more than 7 years, and those conditions are that if a person is under 16 years of age, means if a 15-year-old person has committed the murder, then normal circumstances says
that the case will filed in the CGM, CGM will commit the case in session, session will give the bail. But if the person is less than 16 years of the age, then the CGM has the power to grant bail. Understand this thing. And here it is written, person is under 16 years of age. Person is written, not man or a woman. So that person can be a male, it can be a female, and it can be a male, it can be a female, or it can be a transgender. 16 years of age or is a woman, means a woman can be of 19-year-old also, 40 years old, or 60 years old. So if it is a woman and the woman has committed a crime where the punishment is more than 7 years, the CGM can give the bail. So if you are practicing, you come across such cases where your client is women, first straight away apply the bail application in the CGM. Now, if you ask me that, sir, why so special provisions for women? Why is it or for children? Where is the sense of equality? Where is Article 14? Why? Because everyone is equal in front of the law. The English jurisprudence and the American jurisprudence says that every person should have the equal protection of the law, equality before the law, and equal protection of the law. Understood this part? Now, Article 14. But then I will say, please read Article 15, Clause 3. And Article 15, Clause 3 says that the Parliament has the right. Article 15 clearly says that the Parliament has the right to make special laws for women and children. And if the Parliament makes special laws for women and children, it is not arbitrary and it does not violate the principle of equality, and it is not discriminatory. Okay. Now, see, that is how the law is made. Why? Because if you ask, you must have read the jurisprudence, which says that what are the sources of law? Three basic sources. First is the custom, then is the then it can be precedent, means if the court has given an order, it can also be a source to make law. And legislation means one legislation can also be a source to make another legislation. For example, Constitution of India becomes a legislation or a benchmark legislation or a benchmark source for the other laws to be made. Regarding the IPC, we have so many laws which has come out of the IPC, where the IPC has been a major source, which are Protection of Women from Domestic Violence Act, POXO Act, Dowry Prohibition Act. Okay. So these are what laws? Where Prevention of Women from Sexual Harassment Act. Okay. And these are what act? These are the act where the IPC has played the role of a source. Now coming back to the CRPC again, means a CGM can give bail to a person where the punishment is more than 7 years if the person is less than 15 years of age, if the person is a woman, or is infirm, or is sick or infirm. Infirm means if it has any physical or mental disformity. So here it is writing sick or infirm, means or this word is used. So here it is equal, the woman is equal to the 15 years old person, the woman is equal to sick, the woman is equal to infirm. Sick. And now read this part, it is just written sick. Nowhere it is written sick man or a sick woman or a sick transgender person. No, it is just written sick. So a person who is suffering from any perennial disease, you can submit your first bail application in. You will submit your first bail application. I am again repeating you. You will first submit your first bail application in the CGM court, then Court of Session, and then High Court. So if you come across such client, don't be in a hurry that, okay, Rahul sir has told that more than 7 years, you have to go to the Court of Session. then you will forget about this proviso. And that is why reading books is not a good practice. Why? Because what will happen? Because in section 437, we have 7 subclauses. And every 7 subclauses are, are again different from each other. Okay. Now what will happen if you start reading a book? When you will be reading a book, what actually happened in that case? If you are reading the book, what actually happens is that if you start understanding one particular subject, you will mix all the concept of 7 subclauses. Okay, and the only thing which remain in your mind will be section 437. But if you read section 437 clause 1, 2, 3, 4, 5, 6, 7, all the subclauses are different from each other. And that is why reading the bare becomes important, so that first you understand what are each clauses and subclauses of every section talks about. Then only you move forward. Okay. Now, this much part is clear to you, bail application part, and I'll not go much into the detail. Only the fact is, section 437, it also says that and at any stage, whether the trial is completed or the trial is going on or the judgment has been delivered, you can get bail, you can apply for the bail, which clearly says if you are going into the criminal practice, always remember one thing: bail and trial goes parallel to each other. When you apply for the bail application, you never, when you apply for the just give, I'm really sorry. Uh, I'm really sorry. Now, things are clear now. See, bail application you have understood. Always remember in your practice, when you will be appearing as an advocate, bail and trial goes parallel to each other. Okay. They always remember, in trial, you always decide whether the person has committed the offense or not. Okay. And in trial, you argue always on the merits of the case. Always remember this thing. In the trial, you always, if you want to write it down also, please make a small note. In the trial, you always argue on the merits of the case. And in the bail, always remember, never ever argue on the merit of the case. In the, again, I'm repeating, in the bail, never ever argue on the merits of the case. Okay. I hope this punch part is clear to everyone. never argue on the merits of the case. In the bail application, you have to just argue whether the person should be granted bail or should, and these are the conditions which will follow and why the person should be granted bail. Okay. Now, if the judge grants the bail, he will again write it down the reason under section 437 clause 4. It will write down the reason that why the judge is granting the bail, and if the judge rejects the bail, then also the judge the judge write down the reason why it is rejecting the bail. Always remember, the judge has to give the reason why it is granting the bail, why it is rejecting the bail. This much part is clear to everyone. Okay. And as per section 437, it clearly says that whenever that the bail can be taken at any stage of the case, whether the judgment is delivered or not, or whether the trial is completed or not. It simply means that the bail and trial in criminal cases always runs parallel to each other. They have got no whatsoever connection with each other. In the trial, always argue on the merits of the case, and in the bail, always argue on the technical ground. Now, if you remember, I had stopped at the place which I called regular bail. Now, how many types of bail are there? Now, see. And if the bail is rejected, please make a small note somewhere, because last 10 minutes are left for the bail application, and then I'll move for the other networking resourcing part, and then I'll take questions. Okay. See. How many anticipatory bail? The bail which is taken before the arrest. Now, regular bail is when a person is arrested, he's in the jail for a considerable period of time. You apply for the regular bail. Then you must have come across a term called interim bail. Okay. Then you must have come across a term called default bail. Okay. Now, please make a small note and write it down somewhere. Please write it down somewhere that please write it down, the bails, all the bail are, all the bail are interlocutory in nature. All the bail are interlocutory in nature. Okay. Except interim bail. Okay. All the bail are interlocutory in nature except interim bail. Full stop. Full stop. No appeal, comma, no appeal, comma, revision, appeal or revision, no appeal or revision can be filed against interlocutory applications. Interlocutory application. So मोटा मोटा यही है कि if a bail is granted, then the prosecution will go against the bail. If the bail is rejected, then the defense will go against that order. But in the superior court, what will they file? Whether they'll file bail application, whether they'll file revision, whether they'll file what? The appeal. See, I have told you to write a word called interlocutory. See, interlocutory is nowhere defined in CRPC or IPC or even in Indian Evidence Act. It is defined more or less in CPC. So, interlocutory means that such cases which do not affect the merit of a case, or which does not affect the final decision of the case. Okay, such orders are called interlocutory. Why? Why bail are interlocutory in nature? Why? Because if accused is released on bail, it does not mean that the accused is acquitted. The accused is acquitted only when the accused is acquitted only when when the accused is acquitted only when the accused wins the case. Okay. Otherwise, he is simply on the bail, and if he is in the bail, we cannot say whether he is the guilty or not guilty. Nothing can be said. No, that is why bail application are always interlocutory. If the bail is rejected, the accused file a bail application again in the superior court. He will not file any appeal or any revision. Always remember this thing. He will not file this. He'll always file bail application again in the superior court if the bail is rejected. If the bail is granted, then the prosecution will file in the superior court regarding, they will file cancellation of bail. They will not file an appeal, or they will not file an revision, but they will file for the cancellation of. Why? Because bail are interlocutory in nature, and if it is an interlocutory order, then no appeal or revision can be filed against interlocutory order. I hope this much part is clear to everyone. Okay. Now I
Yes, sir.
told you that in interlocutory application, except for interim bail. Now see how does interim bail is scenario is fixed. First, the accused is whether he is arrested, or let's take an example of anticipatory bail. You will understand better. A person gets a police notice, or a person feels that a complaint has been filed, and the complaint, not FIR, the complaint has been received by the police officer. The police officer has sent what actually happened, that usually where the punishment is less than 7 years, now after the Arnesh Kumar judgment, there is no automatic arrest, and even if it's a non-bailable offense and the punishment is less than 7 years, the police officer always sends the notice of section 41A to the accused. The accused receives the notice, he either prepares the reply, or he goes to the police officer, and he attends all the investigation, all the questions, and he answers, and he leaves. And then when the police officer reports that whether the arrest is necessary or not, he will transfer the report to the DCP. DCP says that arrest is necessary, the accused is arrested. Now, if the accused is apprehending that whether he'll get arrested for sure. Just wait, let me see what all things are left for today's webinar. Dishonor panel, okay, fees, fine, fine, fine. More or less I've covered everything, but I'll explain this thing also. Now, the accused feel that he will get arrested. Now, what will happen is he will file, he goes to an advocate. The advocate, what he'll do is he'll first file an bail application. That bail application will be, that bail application will be what? The bail application will be interim bail application. So now suppose the accused receives a notice on 20th of August, and on 23rd August, I file a bail application. Whether the opposite party is present or not, I will simply say that please at least grant me interim bail. Okay. Please grant me interim bail so that the police does not take any coercive action against me. These are the facts of the case, and these are the reason that I'm not guilty, and I'm been trying to frame. The court will do what? The court will fix a final date of hearing. Let's for an example, let me see the calendar first. The court fixed the date of hearing on 4th of September, final bail of hearing. So I get interim bail from 23rd August to 4th of September. So in these 12 to 13 days, I cannot be arrested. This is my interim bail. And this much time is given to the prosecution to come and argue and apply for the cancellation of bail. So the if when you read the beret, the magistrate always issue the notice to the public prosecutor or the assistant public prosecutor. The prosecutor with all the evidence will come on 4th of September. He will argue, and if the magistrate is convinced that the bail is granted, then on 4th of September, he will grant the bail. Understood? Or if the magistrate is not convinced and he feels that the prosecution is right, he will cancel the bail and he will commit the accused to the custody. And he'll say, fine, take him to the custody. I grant 4 days custody, 5 days or 10 days custody, police custody. Okay. So on 4th of September, the final bail hearing will take place. And against the order, if the bail is granted, the prosecution after 4th of September, the prosecution will file what? The prosecution will file cancellation of bail. And if the court, obviously it will be the sessions court first, because it's an anticipatory bail application. If the anticipatory bail is rejected, okay, then the accused will file anticipatory bail in the High Court. Why? Because if the bail is rejected, accused file the bail application again in the Superior Court. If the bail is accepted, then the prosecution file cancellation of the bail. No appeal, no revision. But there is a catch. The bail granted on 4th of September. The bail granted on the 4th of September is the bail, and such against such bail, no appeal or revision lies. But the bail granted on 23rd of August is interim bail. So against interim bail, always remember in criminal law, if the judgment is passed, you file an appeal. If the order is passed, order is the every day the judge passes on the date of hearing against the case, the judge passes the order that whatever he has heard, allowed, adjournment, provide, everything, that is the order. Against the order, we file revision. So what I told you to write, bail application are interlocutory application except interim bail. So if the interim bail is passed, you can file revision against interim bail. Please write it down somewhere. We can file revision against interim bail. There was a landmark judgment given by Supreme Court of India which justified this thing, that revision can be filed against interim bail. Okay, you have to, it is your revision, you have to find me that judgment. Okay, this much part is clear. So the bail part is cleared. Now the last part in the bail is default bail. Now again, section 437, I think the subclause 6, it talks about what is default bail. See, now as per Supreme Court Supreme Court's judgment, the moment the person is arrested, okay, the remand period starts. So the police officer arrest a person on 20 for an easy calculation on 21st of August. Okay, he is brought to the magistrate on 22nd of August. The magistrate grants 10 days police custody. So 21st to 22nd, 23rd, 22nd, 23rd, 24th, 25, 26, 27, 28, 29, 30, 31, and 1st September. So one day, the person when he was kept in the police custody, that day, and 10 days of police custody. Till 1st September, the accused is kept in the police custody. for 11, sorry, for those 10 days. On 1st of September, the judge again says 4 days police custody more. Means 2, 3, 4, 5. Okay? Till 5th of August, the accused remains in the remand period. 15 days remand period. Then again, the accused is brought to the court. Now, 15 days remand period is given. Now, only two things will happen. First, police custody will not be granted again, first of all. Second, police custody will not be granted. Then on 6th of September, only two things will take place. Or then the second thing will take place, which is the bail application. Okay. Now in the bail application, what will happen? Now, in the bail application, what will happen is that where a defense will ask for the bail. If the bail is allowed, fine, the accused will be freed. The prosecution will oppose the bail, and if the magistrate feels that no, I should not grant him bail, then the bail is rejected, and at that point of time, he will be sent to judicial custody. He will be sent to judicial. He will be sent where? To central jail. Okay. And then again, the other calculation starts. It says that the police has to file the charge sheet. Okay, the police arrest a person, register the FIR, the police arrest the person, then the police starts its investigation. If the police feels that the accused has not committed the offense, okay, if the police feels that the accused has not committed the offense, the police in the court files the closure report that we are closing the report. If the police feels that accused has committed the offense and the police has enough evidence, then they will compile all the evidence, they will prepare a report, and they will submit that charge sheet in the court. And what happens is that the police also has to file an occurrence report on every 15 days. Okay, and every 15 days he has to inform the magistrate that what all investigation has taken further in last 15 days in this particular case. Now, as per section 437, it says if the offense is less than 7 years, always remember this thing. If the offense is less than 7 years, the police has to file the charge sheet in 60 days. Okay, the police has to file the charge sheet in 60 days. Means, and that 16 days will include that 15 days remand period also. So 15 days remand period, 45 days police judicial custody, means within 16 days the police has to file the charge sheet. And if the offense is more than 7 years, then the police has to file the charge sheet within 90 days. Means 75 days of judicial custody, and then 15 days of police custody. So 75 plus 15, it becomes 90 days. Now, if the police does not file the charge sheet, then on 61st day, where the offense punishment is less than 7 years, then on the 61st day, and where the punishment is more than 7 years, on 91st day, the accused is eligible for the bail by default. Bail by default, and that is what is called default bail. Okay, that is called default bail. Understood this much part? Default bail. That's what we call it, default bail. Now, the thing is, for that also, the accused has to apply for the bail himself, and the police, if the police has not filed the charge sheet and the police does not provide any reasonable reason that why the police has not filed the charge sheet on the stipulated time, then on the 61st day or on the 91st day, the accused is eligible for the bail by default. That is what we called default bail. Understood this much part? So this was bail for you. Now, I'm open to any question which you want to ask. Then I'll talk about research, networking, how to find senior, check dishonor case, and the growth fees and other things. Okay. So now I give you 5 minutes of time. It can act as break for the other person. Please ask your doubt, and then I will I will go for bail. I have understood divorce and police case. Okay, 1, 2, 3, 4, 5, 6, 7. Okay, so if anyone has any question, please ask now.
Sir, if you don't mind, could you please share your number? I live in NCR itself. Hello.
Any questions? इतना अच्छा पढ़ा दिया क्या मैंने? किसी को कोई क्वेश्चन डाउट नहीं है?
सर आपसे कैसे मिल सकते हैं, और अगर आप अपना नंबर दे सकते हैं तो वुड दैट बी।
Any doubts?
If anyone has any questions or doubts, please turn on your mic, or you could like write down in the chat box. Okay, no response. Then I suppose you all have understood. So we can proceed with the next one.
Okay, I'll complete the session now. Just wait. Okay. Now, regarding the legal research, always remember, my dear students, is that in your research is something. It is a very famous line that the Napoleon didn't lose the battle of Waterloo. Napoleon didn't lose the battle of Waterloo in the battlefield. He lost the battle of Waterloo in the fields of Manchester. Why? Because the English soldiers were well prepared. Okay, they were well prepared, and that is why they lost the Battle of Waterloo. Because of the paucity of time, and I don't want to stretch the session for very long, I'll start giving a few examples. Okay, now in the same manner, always remember this thing which I'm telling you is that the great lawyers never win the case by the argument done in the court of law. The great lawyers never win the case by the argument done in the court of law, but they win the case on the legal research done in their chambers. Always remember this thing. They always win the case on the legal research done in their chambers. It is a fact. Okay, I'll give you a small example that there was a case of a check dishonor case. The party has switched the advocates and they approached me for the case. And what happened that I found out that there was a huge mistake in their criminal complaint. Okay, and I was like that. Now what is supposed to be done? Okay, now what is supposed to be done? What do we have to do? Then it was decided that I have to go to the I have to amend the criminal complaint. Now always remember, in civil cases you can amend your complaint. Okay, but in criminal cases you can never amend your criminal case. Why? Because we have a principle of estoppel. Estoppel means whatever you have accepted, then it cannot be rejected at this. Uh, sure. I'll do that. So, whatever you have accepted once, it cannot be rejected at the later stage. But then I researched and I came across three Supreme Court judgment, and one was related to check dishonor case itself, and and it simply says that amendment of criminal case is allowed, although it is not mentioned in CRPC, although it is not mentioned in CRPC, but amendment of criminal case is allowed provided it fulfills two conditions. First condition is that it should not change the nature of the case. First condition. That आपने ऐसी amendment कर दी कि केस का नेचर ही बदल गया, you have seen that meme that वक्त बदल गया, जज्बात बदल गए, okay? That thing should not take place. Means that it should not change the nature of the case, first of all. Second, it should not do any prejudice. It should not do any prejudice. Rithi, I've sent you my LinkedIn link on your WhatsApp, okay? It should not do any prejudice to the other party. Okay, so if it does not do any prejudice to the other party, in such cases the criminal case can be amended. So that was one instance where my legal research held me in my case. Okay, there was another case where I was assisting my senior, and that is where my skill of legal research held me. That there was a case where the central government employees are always eligible for all the health benefits. Means CGHS health scheme is their central government health scheme. Means whatever money you give to any hospital which is on the panel of central government, after the operation, that money is refunded to you. Okay. Now what actually happened that there was a retired police officer. He went to USA to meet his daughter. There he suffered a cardiac arrest and he was arrested and he was admitted immediately, and immediately medical expenses operation had to be done to save him. Now what happened that he a particular medical bill come across. Now he applied for the medical bill for the reimbursement in the central government because he was a central government employee. Okay. Now the central government health scheme rejected that you took the medical, you took this medical treatment outside India, so will not reimburse anything. He went to the court, and my senior had taken the case. And what actually happened that I came across a judgment, and I held with the judgment which said that even if at the emergency period a person who has not gone to the foreign country to take the medical treatment, but has taken medical treatment at the emergency state at that point of time in the behalf of natural justice, he should he should be able to he should be able to he should be granted all the reimbursement. Okay. Now comes to the how to find senior and networking part. See, always remember one thing. First of all, the better your legal research is, the better your presentation will be. Okay, the better your presentation will be. And regarding your seniors, always try to see regarding the growth. I'll always advise that the growth in criminal law in the initial stage is slow. You won't be earning quick money in criminal practice at the initial stage of your career. It is a fact. But that does not mean that you will opt for some illegal means to attain to get some quick bucks. No, it's not the case. Now, regarding the senior, always try to find a senior to join a chamber who has a practice of close to 10 to 15 years. See, if you join a chamber where the senior has a practice of 35 years, see, he will be really much, he will be pretty much preoccupied with his work. Okay. So there is huge chances that able to, he won't be able to give you much time to in fact teach you or to guide you in a proper way. But at the 10 to 15 years of practice advocate, they are usually at their growth stage. So that is where you will understand that what all hard work and what all things an advocate do to uplift his practice, and what all mistakes he has done, which you can avoid in your journey, and you can closely watch his journey, that how he becomes successful and how he tries to get the cases, how he handles the client. Why? Because he will be in a position that he will be able to give you much more time. Okay. So this was regarding this, and now regarding the legal notice part. See, just give me 2 minutes break. Huh? Now, see, whenever you draft a legal notice, and I'll tell you a trick, even if you don't know the address, okay, even if you don't know the address, simply send the legal notice on the accused either last known address, which you have to prove in the court that how come this address was the last known address to you. It can be through any means of communication or anything, or the accused last registered address. You have to send the legal notice there. Okay. This is one trick. And always remember one thing, especially in check dishonor case, whenever you send a legal notice, okay, whenever you send a legal notice, the limitation, we have a limitation period and then we have a notice period. So the notice period is, suppose you send a legal notice on 23rd of August. The accused receives the legal notice on 25th of August. Okay. Then you have given the notice period of 15 days, that within 15 days, you please reply to the legal notice or else I'll file the case. Okay. Then what will happen? Then in such cases, when you have sent the legal notice on 23rd of August, the accused has received the legal notices on 25th of August, you have to count the notice period from 26th of August. You will never count the notice period from the day you have sent the legal notice. Always remember this thing, which is 23rd of the August. You will never count the notice period on the day the accused has received the notice, which is the 25th of August. Okay. You will always count the notice period from the next day the accused has received the notice, and you will count like this. Suppose that you have sent the legal notice 23rd of August, you will not count 23rd August, you will not count 24th August. The accused has received the legal notice on 25th of August, you will not count 25th of August. You will start counting like this: 26, 27, 28, 29, 30, 31. 6 days this, and 9 days of September. On 9th September, the notice period of 15 days will be completed. Okay. Then you cannot file the case on 9th of September. Always remember, judge case ko reject kar dega. You will never ever file the case on The last day of the notice period, you have to ensure that the entire notice period is completed of 15 days. And you will file the case on 10th of September. Always remember this thing. ये वाला part, ये calculation समझ में आ गया सबको? Please say yes in the comment box.
Sir, could you please repeat?
Have you understood this calculation? Good. Means
Sir, could
today
you
I've
please
got
repeat?
a intelligent crowd. Means they're pretty understanding what all I have told them. Great. It's a good sign then. Now, regarding the cases, always remember one thing, because I'll now quickly wind up because it has become quite long and I should have, it was my fault. I shouldn't have, because earlier it was planned as an offline event. So that is why I kept 3 hours schedule. Otherwise, had it been online from the start, I would have kept 2 days schedule only, and I've shared my LinkedIn ID to you. Okay. Had it been online from the start, I would have kept at max 2 hours of webinar, not 3 hours. And because earlier it was planned as 3 hour offline event, so that is why I have just kept. That is why I kept. 3 hours schedule. Regarding the divorce case, always remember whenever you come across a case where the domestic violence has also taken place, always remember one thing. In the case where the divorce case will be filed, the divorce case are always filed in the family court. The family court, usually a ADJ level judge presides the family court, means he sits on the family court. ADJ court means a judge who has the who is in the sessions court. That judge will sit in the family court. Family court is civil court. It only decides whether the divorce will take place or not, whether it was a proper voidable marriage or not, whether it was a void marriage or not, whether the maintenance will be provided or not, or whether if there is a lapse in maintenance, then the remaining arrear on the maintenance will be given. Okay, understood this much of what? Okay, this thing will be covered. Regarding the domestic violence case, always remember one thing. You will file an FIR, the accused will be arrested, he will get the bail, or the police will again go through the provisions of Arnesh Kumar. See, what actually happened that the provision of 498A of IPC was also misused a lot. So, what the Supreme Court case went to the Supreme Court, and in the Arnesh Kumar versus State of Bihar, 2014, to Supreme Court, it was decided. It was decided in that case. It was decided in that case that the police will, if the FIR is registered, then there shall not be any automatic arrest. Okay, then there shall not be any automatic arrest, and there shall not be any automatic arrest, and the police will first conduct a preliminary inquiry that whether the any domestic violence case has taken place or not. And once the police is convinced, only then the police will arrest. Okay. And then, although section 498A is non-compoundable in nature, means the compromise cannot take place either once the case has been started, either it will go into the acquittal or into the conviction. But after the guidelines, now it is one of the rare case, usually at the district court level, if the husband and wife are separated, or if they wished to live together again and not to take divorce, usually the magistrate allows the compounding of the offense. The magistrate will call both the party, they will record their evidence, and then it will compound the case. Okay. Now what happens? The family court is at the level of sessions court, but for the domestic violence case, the case goes to the court of JMFC. Always remember this thing, JMFC court. Why? Because in the section 498A, the punishment is up to 3 years or fine or both. Now, one more thing, or fine or both. So when the punishment is up to 3 years, the case always goes to the JMFC court, and there is no comparison of a JMFC court and a sessions court. Okay, so both the case will be held and tried together. Will in the not together, in the separate courts. Always remember this thing. And always remember, last but not the least, yes, it is good to be Krantikari type, but never ever take panga with police officer. Why? Because once a criminal, even if not just the police officer, but try to avoid to stay away from the criminal case, avoid the situation where anyone can file a case against you. Like suppose it can be a petty offenses, like someone is drinking alcohol in the streets, so obviously excise act will be imposed on him, and he'll be sent to jail. Or even if he's not sent to jail, if he pleads guilty that, okay, I'm sorry, I'll not commit the mistake, the judge will not send the person into the custody, or the judge will not send the person into the imprisonment or in the jail. But the judge will do what? He will just say, okay, I'm imposing a fine of 500 rupees or a 1000 rupees. So even if when the court imposes a fine of 1000 rupees, okay, as a part of judgment, means whenever you read in IPC petty offenses, now where the punishment is up to 1 year or fine or both, means jail plus fine, or only jail or only fine or both. So even if the court imposes a fine as a penalty, then always remember one thing: you are guilty in the eyes of law. And once you are guilty in the eyes of law, such students are not eligible for any government job. Are you getting it? So always try the situation where you have to face police case, because once the police case is done, then you cannot apply for any government job. So thank you very much. Thank you for being patient throughout. So now I'll end the session now. Okay. So if you have any doubt, you can ask your doubts.
Participants, if you have any questions, any doubts whatsoever, you are free to ask your questions, or you can write down in the chat box.
Any doubts? Regarding the check dishonor case, I will tell you. See, what actually happened in the check dishonor case. If the check is dishonored, okay, let's take an example on 16th of August, okay, you have presented a case. Just give me a second. So you have presented a check in the bank on 16th of August. Okay. On 16th of August, the check is dishonored. Then what will happen? The bank will send you the notice. Sorry, the original check along with the official bank memo with the reason that why the check is dishonored in an envelope. You will receive the envelope. Okay. You will receive the envelope. And now the check is dishonored on which date? 16th. But you will start counting your dishonor date. That bank will send on envelope on 17th. You have received that envelope, the bank memo on 19th of August. So when you will read clearly,
about the check dishonor, about the section 138 of NI Act, what will happen that it has clearly mentioned that first it should be a legal money. It should not be an illegal money. Means you cannot say that okay, I've earned this money by selling drugs and I gave this money as a loan to my friend, and now my friend is not returning the money. No, sorry, it's not allowed. The money should be a legal money. And when you'll read section 138 of Negotiable Instrument Act, it clearly says that anyone who commits the crime of dishonor of check, it will be punished for a punishment, imprisonment up to 2 years or fine or both. So when the punishment is up to 2 years, means what? If the punishment is up to 2 years, the case goes to the JMFC court. ये तो clear हो गया. Always remember one thing, and then if the check is dishonored, the bank sends you the notice. Then, as per section 138 of Negotiable Instrument Act only, it follows the rule of 30, 15, 30. Okay, 30, 15, 30. What happened is, check is dishonored on which date? 16th of August. Once you have returned the date 16th of August, the life of a check is always 90 days. Remember this thing. The life of a check is always 90 days. 60, okay, 30, 15, 30. 90 days के टाइम रहती है उसकी, ठीक है, 90 days का उसका टाइम रहता है. So 16th of August means the check can be presented in bank n number of time till which date? 16th of September, August का date लिखा है, so 16th of September, 16th of October, 16th of November. So the check is valid up to 16th of November. Now you have presented the check in the bank on 16th of November. The check is dishonored. You get the bank memo on which date? On 19th of September. Then your first 30 days start from, always remember, जिस दिन आपको बैंक मेमो मिलता है उस दिन से आपको स्टार्ट नहीं होगा. It is always from the next date. Okay. Now the limit, it will start, the notice starts that from 20th of August till 19th of September. In those 30 days, you have to send the legal notice. 30. And suppose you are vigilant enough, you have sent the legal notice on 23rd of August. Okay. The accused receives your legal notice on 25th of August. Then I have told you the calculation. Then from 26th, the notice period will start of 15 days. So once you have received the bank memo, within 30 days, you have to send the legal notice. After sending the legal notice, you will not calculate the 15 days period. The moment accused receives the moment you send the legal notice, no. Or the moment accused receives the legal notice, no. You will always calculate the notice period one day after the accused has received the legal notice, and you have to give the accused full 15 days. So within 30 days, you have to send the legal notice. Within 15 days, you have to wait as a notice period. And once the notice period of 15 days is over, then within 30 days, you have to file the criminal case. 30, 15, 30. If you don't file the case within those 30 days, and if it is in the validity of check, then simply again place the check in the bank, place it in the bank, get it dishonored. This time send the legal notice on time and don't wait, and then file the case. If you have completed those 90 days and you have not sent the legal notice on time, or due to any reason you have not filed the case on time, then what will happen? Then in such cases, then in such circumstances, what actually happens is that then in such circumstances, you will first file the case in the JMFC court, appealing for condonation of delay. You will explain that why there was a delay in filing the case. Once, if the judge is convinced, he will condone the delay, and you can continue with the criminal trial. And you'll continue with the criminal trial. But
If the judge is not convinced, the judge will do what? The judge will dismiss your case. Then you can file a civil case. For civil case, always remember you have to give the sorry, you have to give the court fees to the court. The last thing about the court fees, you must have heard about this thing that if regarding the court fees, that if you win the case, you will get the court fees. If you lose the case, you won't get the court fees. It is never the case. If you lose the case, fine. If you win the case, the court ensures that the defendant gives you the court fees. The court never gives you the court fees. The court never reimburse, or you can say refund the court fees. Okay. Now I've started getting doubts, sir. I have a question. I'm preparing to go into the litigation after studies, but I'm preparing my CV for corporate too, just in case I don't make my play litigation. So for getting decent corporate jobs, Ayush, learn contract drafting, and if the money is also a priority, go for corporate litigation. NCLT litigation, tribunal litigation, because now you have seen that data protection law has also been enacted, and for that also a tribunal will be made, and the data protection cases will have been, as of now, has been made as a civil offenses, sorry, civil cases. So it will be filed in the civil court, civil tribunal. So that will be a good place for you. Okay. Any other doubt?
Participants, if you do not have any other questions, then we shall wrap up this seminar. We would request everyone to please turn on your video so that we can take a picture with sir. All right, we have one question.
Any other doubts? Okay. How to remove
Shafik.
confusion whether to choose civil? See, first of all, you have to decide, Supratim, that whether you want to work in a government job or whether you want to do practice. Because practice is something, it will take time. If you feel that no, I'm more inclined towards government job, I want bar, simply go for judiciary. And even if you don't crack judiciary, then the knowledge which you will gain after your preparation, it will not go into vain. Always, and it will help you only. Okay. And regarding the civil and criminal litigation, once you start practicing you will ultimately understand that whether your interest lies in the civil or uh, uh, criminal. Sir, would be a first generation opt for? Yes, you can. It's nothing like that. Even I'm a first generation advocate.
Participants, any other questions?
Any other doubts? Any other doubt? Okay, we can end the meeting now, Ritik.
Yes. Yes, sir. All right, participants, I would request you all to please turn on your video. Sir, I would request you as well. We will take a picture, and with that we shall bring an end to this seminar. We thank you again for your time, for your patience, and we hope helpful to you. And we also thank Rahul Sir for taking his time off his busy schedule. I know how difficult it was, but thank you nevertheless. on behalf of the journal and seminar committee. Participants, please turn on your video.
Thank you.
Thank you, sir. So much for your time. All the information regarding the LinkedIn search profile and the PDF of this seminar will be shared with you in the group itself, as well as the feedback form. Also, this is to let you know that we will be hosting more webinars and seminars. So you can follow our social media platforms. We are on Facebook, Instagram, and LinkedIn as well. The information, all those informations will be shared to you in the group in itself. And we are also taking in submissions on a rolling basis. It includes any articles, essays, or research paper as well. So you can send your articles on the topic we had today. I'll share the official ID, committee ID with you in the chat box and also in the group, so you can send there. Thank you so much for your presence. We hope it was helpful and insightful for you. We request you to please leave the meeting now. Thank you. Have a good day.